Good evening, everyone, and welcome to Unit 7. This is Professor Libby, for those of you who don't recognize my voice by now. Again, as a general reminder, hold on, my music was supposed to pause. Little U2 here. As a general reminder, I have gone ahead and graded the assignments for Unit 6. I noticed a couple of you have submitted assignments in the last few hours, so I will be looking at those tomorrow. Also, there are zeros in the grade book for anyone who has not submitted all of your assignments from the beginning of the class through the end, so the grade book is complete for the assignments. I will be grading the discussion board tomorrow. I also noticed a couple of you posted there today, so I will capture those posts this time and allow them, even though they're a little bit late. But for anyone else who has not reached out to me or responded to my emails, do let me know your status so that I can work with you and try to get you caught up. The end of the class will be here before you know it. It seems this course has really flown by. So again, I'm here to help. So please do not hesitate to reach out to me if I can assist you, okay? So let's go ahead and get started. This week we'll be talking about tort law, which is civil law as compared to criminal law that we discussed last week in Unit 6. So I will be continuing some of the comparisons between what we talked about last week and the aspects associated with civil law, specifically tort law. So on that note, here's an overview of what I'll be going over this evening. As usual, I'll be going over the syllabus, which are the activities that you're responsible for this week. Additionally, I'll be going over the learning objectives. Hi, Kristen, that's fine. I'm actually noting some of you who came in late, so let me just real quickly check you off. I can do it in the record, but sometimes it's not all that accurate. So, okay, I think I've got everybody. And on that note, if you ever see your seminar grade and you were in the seminar, if I've made a mistake, absolutely reach out to me and let me know you're in the seminar, because I can go back and look at the transcript for the seminar and see if perhaps I missed you in attendance. So again, do not hesitate to reach out to me if you believe you were there, or if you knew you were there and I don't have you. If there is any discrepancy, I will go ahead and reach out to you, okay? So on that note, I was going over the overview for tonight's seminar. I'll be going over the learning outcomes, and then as I just mentioned, our topic this week is tort law. On that note, you will have your usual discussion board where you'll be talking about a particular category of tort known as negligence and some of the defenses associated with a negligent action, as well as potentially an intentional tort action. So don't let the title of the discussion board trick you, because when I go over it tonight, I'll explain in a little more detail what I'm talking about, but pay attention to the fact pattern in what I talk about tonight and don't focus too much on the title of this week's discussion board. And then as usual, if you have any questions regarding anything that we've covered so far in the class, you can absolutely feel free to share those questions in tonight's seminar. And as you hopefully know by now, you can also share those questions in the discussion board and receive credit for doing so. So here's the slide detailing the specific learning objectives. Again, these are the concepts you should be mastering at the end of this unit. At the end of Unit 6, you should be able to adequately explain what is meant by tort law and the relevance of tort law in our legal system. Additionally, be able to identify and generally explain the three major types of torts that I'll be going over this evening, and then explain some of the elements that a plaintiff must prove to establish negligence. There are 4 elements, and again, I will be going over those tonight. Do pay particular attention to them because you will be talking about negligence in your discussion board. Additionally, I want to add another outcome. You should be able to explain the elements to proving an intentional tort, and then the next one is define strict liability, also known as absolute liability, and then generally explain some of the defenses to different types of torts. So essentially, at the end of the unit, you should be able to explain what tort law is, do some comparative analysis to criminal law. Also know that the other side of civil law involves the other major category, which is contract law. Also be able to identify the 3 main types or categories of torts, which I'll be going over tonight. and then generally explain some of the elements of all of those three major types of torts, and then note and be able to identify some of the defenses to both negligent torts and intentional torts. So I'll be going over all of that tonight, so hopefully the readings will complement what I talk about. And as I've noted many, many times, if you have any questions or would like further clarification, absolutely feel free to ask. So here's a visual of what this week looks like. Again, our topic this week is tort law. Make sure that you read chapter 11 in your ebook. Also review some of the various resources in the reading area regarding tort reform. Now, they're not necessarily related to your graded work this week, but there has been a push for tort reform for many years, actually, mainly dealing with some of the punitive damages that have been given by juries that to the bar that defends tort actions seems to be much, much too high, not really reflective of the injuries that have been sustained, more punitive in nature. So again, it's this class used to deal a lot more with tort reform. It has been revised, but the curriculum team decided to keep the aspects of tort reform for your informational purposes only. So when you look at that section and feel like maybe there's no segue to the work that we discussed this week, that's fine. It's really sort of background material as to sort of more current events in tort law. And then finally review the learning activity, which again will help you further understand and practice your knowledge of the concepts that you'll be learning about this week. On the right-hand side, we have your graded activities, which include the discussion board titled Negligence, Torts, and Defenses. You're in the seminar, so again, you don't need to worry about that. And there is no assignment this week. So what I'd like you to do is, for any of you, again, that have outstanding work on getting that done. Additionally, for any of you that have not lined up your interviewee for the Unit 8 assignment, let me know your status. I have created an alternative assignment if you are unable to find someone to interview, or I can make some suggestions in respect to who you might be able to interview. So again, do not hesitate to reach out to me. Don't, stress about not being able to find somebody. We will figure it out and enable you to get it done. Also, if maybe your interviewee has changed the schedule and you need additional time, that's also not a big deal as long as your assignment is in by Unit 10. This is one assignment where I give a lot of leeway as far as time that it's submitted, because I do understand I've had a lot of students that have had to reschedule their interviews for various reasons, particularly, if you're dealing with someone in the legal profession or law enforcement, their schedule is not always their own, okay? So that's what this week looks like. So what are we going to be talking about, and what are you going to be learning about this week in Unit 7? So this week we'll be talking about one of my favorite topics, actually, which is tort law. As you recall, last week in Unit 6, you were introduced to criminal law and criminal procedure. This week, we'll compare how civil and criminal law differ in respect to both substantive law as well as procedural law. For instance, in a civil case, the person harmed is called the plaintiff. Again, civil is tort law. The plaintiff files a complaint seeking the court's help in resolving a dispute, usually seeking monetary damages, while the defendant is the individual or entity who is being sued and who committed the alleged tort, known as the tortfeasor. So as you'll learn, civil law involves two areas of the law, generally tort law and contract law. There are three categories of torts that we'll be talking about, but it's important to keep in mind the background.
Just checking in, you still there?
Oh, I guess someone's got their, whoever doesn't have their mute on, if you could just mute. Can everyone hear me? I think I'm not sure who's not muted. Looks like everybody is. Anyway, in regards to what tort is a civil wrong that does not arise out of a contract. So when you look at the civil side of the law and a particular action has arisen involving harm, if it's not harm as a result of a breached contract or non-performance of a contract, then you can assume it is tort law. Now, keep in mind that this does not include other areas of civil law, such as family law, probate law, things like that. Those are very specialized categories. So when I talk about tort law and contract law being the main parts of civil law, they're the non-specialized. That's okay. Hold on one second here. That's fine. I'm just responding to one of your classmates who inadvertently switched devices and wasn't muted, which is no big deal. Okay, so when you think about civil law, tort law, contract law, the two main components, and then there are the more specialized areas on the civil side, such as family law, probate law, et cetera, okay? So generally what this means in tort law is that someone suffered physical, emotional injury to themselves or damage to their property because of some wrongful act or unlawful act of another person or a business. As I mentioned previously, there are three categories of tort law. These three categories of tort law that you'll be learning about are intentional torts, negligent torts or negligence, and strict liability, also known as absolute liability. You'll also learn about what damages are possible in a tort action and what defenses a defendant may raise against the plaintiff's case. So as you move through this unit, I'd like you to think about how civil law differs from what we talked about last week, i.e. criminal law, and see how many differences you can identify, as well as what are some of the similarities. So in respect to tort law, when you do your research, make sure you're on the civil side and not the criminal side. Why? Because tort law is part of civil law and not criminal law. When you do your research, you'll often see students who use the terminology of assault or battery, which are both civil actions as well as crimes. We talked about last week how there's the crime of assault and the crime of battery. Well, there's also a tort known as assault and a tort known as battery. If you're in the penal code, that means you're on the criminal side and you should be on the civil side. Now, having said that, some states use the definition, the general definition of the criminal code, the penal code, and refer researchers and legal professionals to the penal code to look at the definition, but then the elements and the standards go back on the civil side. So again, I don't want to confuse you, but generally speaking, you're going to find the elements in the civil side and the elements different on the criminal side, which is the penal side. If there's any confusion when you're doing your research, again, feel free to reach out to me, but it will explicitly let you know if in fact they're using sections within the penal code to supplement the civil code. Okay, again, not to confuse you, but it's not as black and white when you're doing your research as it may sometimes appear. And as you move forward in legal studies program, you'll see that, reading statutory law and reading case law, which is another type of law dealing with both of these issues, is not always straightforward. Now, having said that, the same conduct can lead to both civil liability in a civil or tort case, as well as criminal culpability in a criminal case. The most famous case that most people are somewhat aware of is the O.J. Simpson case. So O.J. Simpson was found not guilty in a criminal case for the deaths of Ron Goldman and Nicole Brown. However, in a subsequent civil case or civil cases, O.J. Simpson was found liable for damages for the deaths of both Ron Goldman and Nicole Brown. Now, again, different causes of action, different burdens of proof. And this is these two factors are probably the number one reasons why O.J. Simpson was found liable for monetary damages in the civil case, but was not found guilty in the criminal case. Why? Because of the differences between civil law and criminal law, namely the burden of proof, which is extremely high in a criminal case and not as high, not even close, in a civil case. Additionally, the victim harmed and the plaintiff are different in criminal versus civil. The goals of civil law and criminal law are, for the most part, different, and the terminology is different in these two types of cases. So let's just real quickly review the differences in the burden of proof. This is the major hurdle that the moving party must overcome. So in a civil case, it's the plaintiff, it's the person who was harmed. So in a tort case, It's the person who was harmed by the alleged tortious conduct of the defendant. So in that type of case, the plaintiff must prove by a preponderance of the evidence, usually more than 50%, that the defendant committed the particular tortious action. Now, proving that is going to be directly related to the elements of the particular tort, and I'll talk about that when I give you some examples of the three categories. So on that note, the torts differ depending upon what the elements are, but the burden of proof always remains the same, again, preponderance of the evidence. So in civil cases, the jury or the judge will find for the party that on the whole, meaning more than 50%, has the stronger evidence, however slight the edge may be. In a criminal case, as we talked about last week, the burden is extremely high. It's a beyond any reasonable doubt. And as we talked about again last week, that means that every member of the jury must find beyond any reasonable doubt that the accused was guilty of the crime and satisfied all the elements necessary to prove for that particular crime. Now, in both instances, civil and criminal, the accused and the defendant, respectively, are given the presumption that the defendant, he or her, is innocent. So again, you can see why the O.J. Simpson cases had very different outcomes based upon these standards. So another difference between a civil case and a criminal case is the terminology and the parties who move forward. So in a tort case, it's the individual or corporation or partnership who was actually harmed. In a criminal case, it's not the victim. It's perceived this theoretical harm to society in general. So the victim as a member of society is represented by the government in moving forward to prosecute for that crime. So it's a prosecuting attorney who makes the determination as to whether or not he or she is going to move forward and file charges against the accused. That's the criminal case. In a civil case, again, it's the individual who actually suffered the harm. So what are the goals of tort law? We talked about the goals of criminal law last week. Let's talk about the specific goals of tort law. So the number one is to compensate victims by holding accountable those people responsible for causing such harm. What is the compensation? In almost all instances, the compensation is a monetary compensation. Additionally, the goal of tort law is to protect people and property from unjust injury. So again, if people understand that if they commit these tortious acts, that they can be found liable for monetary damages, they're less inclined to engage in this type of behavior. So again, it's sort of that deterrent effect that you see on the criminal side. And then finally, to encourage minimum standards of social conduct. Again, this is sort of a combination of, modeling certain behaviors, but also to, support that deterrent effect. So by providing potential punishments, monetary liabilities, and things like that, the goal of tort law is to encourage people, not to engage in tortious conduct and to get along with each other and not harm others in society or harm others' property in society. So again, some similarities between criminal law and tort law. As a refresh, here are the goals of criminal law we talked about last week. Things you can see here that are somewhat the same would include general deterrence and retribution, which is giving back to the victim. In civil law, we have that deterrence goal that is sort of reflected in to protect people and property from unjust injury. Retribution will be reflected in the first goal of tort law, to compensate the victims. The punishment is much harsher in criminal law. It allows the accused who are found guilty to be imprisoned, even pursuing capital punishment, which can put them to death. In civil law, you do not have any sort of imprisonment or capital punishment. The sort of consequence in a tort case is monetary compensation. In equity, to some degree in tort law, there can be equitable remedies, which include an injunction to prevent somebody from doing something and specific performance, which makes someone fulfill their obligations that they might have. So again, different goals, some similarities, but for the most part, the goals of criminal law are different than the goals of tort law. So to define what a tort is. So a tort is a fancy word for a civil wrong other than a breach of contract, for which a remedy may be obtained, usually in the form of damages, i.e. monetary damages. It's a breach of a duty that the law imposes on persons who stand in a particular relationship to one another. This is just the definition from Black's Law Dictionary. You'll find, similar definitions everywhere. But basically, a tort is where somebody has been harmed, either themselves or their property, by conduct of another that results in some sort of damages. Again, it's a civil wrong as opposed to a criminal or contractual cause of action. Now, it's important to understand these specific elements associated with a tort. All of the elements must be satisfied. So you can break them down into 4 parts. A duty owed to one person by another. Again, this is going to depend upon their relationship. A breach or breaking of that particular duty, and harm done as a direct result of the action. This last part of the sentence includes 2 elements: the causation, which is the direct result, and the actual harm. So the harm is not as important as long as there's some sort of harm. It doesn't matter how severe or minimal that harm is. So when you think about the word tort, remember this crazy picture. It simply in Latin means twisted or wrong. So it's twisted or wrong behavior that harms somebody else, for which a legal remedy is provided. So in other words, it's a wrongful act committed by a person or entity known as the tortfeasor, resulting in injury or loss to the victim. Again, the law of torts comes from the English common law, which means that it's generally evolved through the judicial system. That's what the word common law means. So in the U.S., tort law developed over the years largely by judicial law, and more recently through statutory law that restricts or expands tort liability that was earlier created through the judicial decisions. And I assume, Joe, you're saying, what on earth is that crazy picture? Well, that was the result of Googling twisted or wrong clip art. So there you go. He sort of reflects it to me. All right. So tort law generally, for those of you that are interested in tort law, you would likely want to pursue a personal injury practice. So personal injury law, which a lot of people, talk about, they want to get into, deals with lawsuits or claims for money damages for injury that people have suffered. These are torts. The most common type of personal injury case involves automobile accidents. So many of you, or hopefully not too many of you, but some of you may have actually been involved in a tort and you did not even realize it. So now I'm going to go and talk about the 3 categories of torts. It's important that you understand generally what these 3 categories are, but also appreciate the differences between these particular categories, because the standards and the elements are very different. So as I mentioned before, numerous times tonight, tort law provides a civil remedy for injuries. The remedy is in the form of what's known as a cause of action. This is the legal right of the injured party to bring a lawsuit against the wrongdoer, known as the tortfeasor. Now, one of the goals of tort law is to assign financial responsibility, referred to as liability, to the tortfeasor for tortious conduct that has resulted in injury to an individual's property or the individual, him or herself. 3 categories of torts. The first one involves intentional torts. Examples of intentional torts would be assault, battery, false imprisonment, defamation, trespass. The essence of an intentional tort is the intent to do something, okay? So keep that in mind. It may sound, pretty straightforward, but it's easy to get confused when you start talking about the other 2 categories. So intentional torts involve the intent, and I'll talk about that more in a second. The next category includes negligence or negligent torts. These do not involve any intent. What they involve is some sort of non-reasonable or unreasonable behavior that injured somebody else. Most injuries from automobile accidents fall under negligence. There's also negligence actions causing wrongful death, such as medical malpractice, and then just general negligence that could result in many different types of malpractice, such as legal malpractice. And again, I'll be talking about negligence in just a few minutes. The last category of tort law is known as strict liability or absolute liability. This category of tort law deals with defective products, product liability cases, dangerous activities, okay? So as you look at these, and I've sort of already answered this question, but which of these categories of torts are you more likely to have experienced or experienced during your lifetime? So what do you think? Which one of these three do you think you're more likely to experience during your lifetime? And I'll let you answer that as I move on to the next slide. Is everyone awake out there? Has no one been involved in any sort of negligent action? Mitchell says intentional, Kristen says negligence, Sal says all three. No, just kidding. Amanda says negligence. Intentional liabilities, and again, it depends upon your particular life, but most people are involved in negligence action. So again, somebody acted in an unreasonable manner that caused you some harm. Automobile accidents are the number one. Oh, there you go. Misty got sued for your dog biting someone else. Yes, and that's actually relatively common. My dog hasn't done that, but I actually got called into court because my dog was in his yard playing, and a child came over, and the child's mother didn't like that the dog was out in his own fenced-in backyard. But anyway, it ended up being fine. But there you go. So anyway, negligence is the usual one that most people are involved in. Though again, I'm sure some of you may have been involved in other types of torts. And Kristen says I worked in personal injury for a little while, actually. So there you go. So you probably have a much better understanding of this particular week's materials than most people. Misty says, but I never went to court. Renter's insurance took of that. There you go. Okay. I know it's just, there's a lot of litigation about dogs. Yeah, right. Exactly. Get renters in insurance. I've rented too, and I always get renters insurance because yeah. Anyway, I completely agree. Okay. So the first category that we're going to talk about tonight involves intentional torts. Now, just as the definition showed you here, and just as the word intentional implies, these are acts designed by the tortfeasor or intended to harm another person or that person's property. Hence the definition of an intentional tort, as opposed to a negligence claim, which is unreasonable though unintended harm. There are two kinds of intentional torts, those that injure persons and those that injure property. Various examples of intentional torts, as I showed you before, include assault and battery, which you can also find on the criminal side, false imprisonment, intentional infliction of emotional distress, trespass to land and to chattel, which is more intentional tort that harms property, and conversion, also one that harms property. There are also some defenses associated with intentional torts. The defenses are generally unique to the underlying tort. So, for example, a defense to an intentional tort of battery to another person or to yourself could be defense of others or self-defense. So again, when you look at the particular defenses that are noted in your readings, and some I'll be going over tonight, I want you to think about some of the unique defenses for the particular categories, and there are some defenses that are shared. So for example, consent is a defense to more than one category of tort. So examples, and I'm not going to go through all of these. I've talked about some of them previously, but again, these are just some examples of intentional torts. And just like other terminology in tort law, do keep in mind that your particular jurisdiction may use a different name. So for example, false imprisonment may not be called false imprisonment in your jurisdiction. Same with interference with advantageous business relationships, etc. Misty says, not going to fib, I got really petty when I got sued, really, really petty renters insurance or not. And Misty, I hear you. When people get involved in litigation, particularly if they've been unjustly accused or need to defend themselves against behavior that they had no, fault in, it can get very messy. And petty, whatever you want to call it. But anyone that's been involved in litigation, and as a lawyer involved in different types of litigation, it can get, petty is actually a very nice word. And Joe says we just got assigned a civil case. Well, there you go. You do criminal law and now you're doing civil law to track with us. So there you go. Wow, $20,000 for a scratch. Oh, well, it's ridiculous what people ask for. The damages that they ask for, they shoot for the moon. That's one of the reasons, actually, I talked in the very beginning of class about tort reform and, the push for tort reform, because some of the awards have been, really not related to the harm that happened. And I agree with you, Misty, even though the insurance companies pay it. I know my husband got in an accident that wasn't his fault. It clearly was not his fault. And the insurance company just settled the case. My husband paid his deductible and let the other car pay their deductible and never attributed fault where it should have gone. And our insurance went up. So yeah, I know they tend to just settle. They don't even look at the merits, and that's a whole other conversation. But I definitely feel your pain. Johanna says the relationship between lawsuits and insurance is something I never thought about. Some of the competition are sky high. This medical insurance and auto insurance also skyrocketed. That's an excellent point, Johanna, and they are very much connected. So for example, if you have homeowners insurance, you have renters insurance, you have auto insurance. Most of those types of claims involve negligence actions. And what the insurance companies often do is they settle the cases rather than going to trial. So whether or not, you're at fault, they will look at the number that's been asked. And if it's not, too outrageous, and I guess to a, multi-billion-dollar insurance company, $20,000 is, no big deal. They'll settle the case. So again, I'm making general statements, but in my experience, and I've done a lot of reading and represented insurance companies, so I know what their standard practices are. So yes. Misty says, fun fact, that the arrows in parking lots are suggestions. A lady also sued me for driving the wrong way down a parking aisle, and she hit me and then said it was my fault. Did not know that. Good, I can drive the wrong way now. But I just learned something. Did not know that at all. So there you go. Oh, you did. I'm glad you won. That is too much. So you guys have had a lot of experience with torts. I don't even need to go any further. So there you go. So as you think about, types of torts, particularly intentional torts, which again require that intent to do something. Here are some of the defenses associated with intentional torts. They include self-defense, defense of another person, defense of property, rightful repossession, consent, privilege, necessity, and the statute of limitations. So again, I don't have time to get into all of these, but for those of you that are interested in tort law, Purdue does offer really good two torts classes actually. There's Intro to Torts, I believe it's PA 165, which spends 10 weeks talking about all these different things. And then there's a more advanced class simply called Torts, PA 310, that deals with more current events and changes and evolutions to tort law. So both are really good classes, and if you're interested in it, something to think about later on. But anyway, these are the defenses associated with intentional torts. But what I want to do now is get through the general categories, and then if I have time, I'll talk a little bit more about the defenses. So the second category of tort law is known as negligence or negligent torts. Negligence is a claim or cause of action that occurs when the defendant owed some sort of duty of care towards the plaintiff, failed to live up to that obligation, i.e. breached that duty, and that failure caused an injury to the plaintiff. There are two types of negligence, negligence generally and negligence per se. The second category of negligence per se, is established as a matter of law, so that a breach of this duty does not become a jury question. Negligence per se usually arises from a statutory violation. So let me give you an example. So the defendant broke the law, statutory law, and because the defendant broke a particular or violated a particular statute and then caused harm, the defendant is deemed to be negligent. This is seen quite often in traffic accidents, when only one party received a citation for a violation of a traffic law. So the party that receives a citation is presumed to have violated the law, and if harm resulted while that party was engaged in violating the statute, then the person is deemed to have breached the duty, and if there is harm, cause the harm to the plaintiff. Now, the plaintiff still has to prove the causation between the violation of the statute and the act actually caused their harm. So again, they're presumed that there was a breach of a duty, but they still need to prove the causation element. And I'm going to come back to that in just a second. So that is the definition of, Joe Thunder says, so because you ran the red light and hit the car, yes, because you created the breach of duty by running the red light, which is a statutory violation. So that would be a case of negligence per se. But you still do need to prove that causation piece. But yes, Joe, that's a good example. So I just also briefly want to go over the defenses, and you'll be looking at this in your discussion board this week. So the most common defense is the defendant's denial of any negligence. And this is done using the reasonable person standard, which I'll come back to. There are also affirmative defenses associated with negligence. Just like when I talked about intentional torts, there were defenses such as self-defense, defense of another person, associated with intentional torts. These are the defenses associated with negligence. In this week's discussion board, you're going to be talking about whether or not there was a negligent act and whether or not there were any defenses. So the defenses that you're going to be looking at, and wait a minute, there should be another slide in between. There we go. I'm sorry. I'm like, where is my 4 elements of negligence? So I'm going to put a pin in just what I was talking about and go back to negligence. Yes, Johanna, you'll be talking about comparative and contributory, which I'm in assumption of risk, which I'm going to go over in just a minute. But first, I want to back up because for some reason I skipped over this slide, which broke down the 4 components of a negligence action. So in the discussion board this week, you're going to be asked whether or not one of the parties would be successful in a cause of action for negligence. In doing that, you have to look at the 4 components, also known as elements of a negligence action. So when I talked about the litigation process in tort law, the plaintiff has to prove, again, by preponderance of the evidence, each of the elements of the tort. So in a negligence claim, the plaintiff must prove, first of all, that there was a duty to act in such a manner as not to expose the plaintiff to an unreasonable risk. So the duty to act reasonably. What this means is anyone in society or everyone in society has the duty to act reasonably and not harm another person or their property. Additionally, there are special duties based upon relationships. For example, there's a special or elevated duty between a parent and a child. A parent has the obligation to keep that child safe, not only to not harm somebody in society, but to keep their child safe and act in a reasonable manner as a parent. Additionally, a lawyer has a duty to act reasonably with their clients based upon the professional standards and ethical obligations of a lawyer. A doctor has a particular relationship and duty that is derivative of that relationship towards his or her patients. So again, the duty is what is going to drive the other 3 elements associated with negligence. So the first one, a duty to act in a reasonable manner, depending upon the relationship to the other party. Number 2, there must be a breach of that particular duty on the part of the defendant. In other words, the defendant, i.e. the alleged tortfeasor, failed to fulfill that particular obligation or duty. Number 3, there must be a causal connection also called proximate cause, between the defendant's failure to abide by the duty to act in a reasonable and prudent manner and the plaintiff's loss or harm, and the result must have been reasonably foreseeable by the defendant. So in essence, the causal connection has two pieces. I'm not going to get into it tonight, but if you do take torts law, they're going to talk about this. So the causal connection has what's known as actual cause, as well as proximate cause. Proximate cause deals with the foreseeability of the harm. Actual cause is the actual action that caused the damage. So for example, the driving of the car into someone, that would be the actual cause. Whether or not it was foreseeable that the harm that occurred would happen as a result of driving somebody into, or driving your car into somebody, that's the proximate causation. Sometimes they're both very easy, sometimes a little more difficult. The last one is that there's some sort of harm, meaning that the defendant's negligent act or omission to act resulted in some sort of injury or loss to the plaintiff. There's no minimum for the injury. So for example, if somebody had their property injured by someone's unreasonable behavior when they had a duty not to act that way in society, and the damage was, $3 to their property. Maybe they, broke a spinning top that cost $3. Would that be a tort case for negligence if all the elements were proven? Yes. Would somebody sue for that? The answer is generally no, because it would cost more to sue than the actual damages. So again, these are some of the considerations that you would look at in respect to actual litigation. So those are the elements of negligence. Back to the slide I had up before, these are some of the defenses to negligence, which you'll also be looking at in this week's discussion board. Specifically, you're going to be looking at comparative negligence and assumption of risk. Some jurisdictions use what's known as contributory negligence, which I'll go over on the next slide. Others use comparative negligence, and some still use the more antiquated defense of assumption of risk or assumption of the risk. Right, Misty, the 128 filing fees, exactly. It's very expensive to get involved in litigation, as you exemplified in your post. Okay, so I just briefly want to talk about the defenses to a negligence action. Now remember, these are defenses to negligence, not to intentional torts. So during the early 1800s, the courts developed a doctrine that barred a plaintiff who brought suit from recovering damages if the defendant could prove that the plaintiff's own actions contributed to his or her injury or losses. So courts shortly thereafter began to universally apply this defense, which was known as contributory negligence. So think about the harshness of this particular application. So if the plaintiff was injured, say the plaintiff was hit by a car, that the person that was driving it was drunk, they drove into the plaintiff and caused $190,000 worth of medical bills, among other things. But the plaintiff at the time was not walking in the crosswalk. So if the defendant could prove that the plaintiff's negligence of not walking in the crosswalk contributed in any way, shape, or form to her injuries, then the plaintiff could not recover anything. This is the concept of contributory negligence. So to address this, by the mid-20th century, because there were some results that just were blatantly unfair, courts increasingly criticized this contributory negligence doctrine, particularly as it related to manufacturers of products and owners and drivers of vehicles. So the courts and also legislatures began to promote changes and adopt a policy called comparative negligence, which I'll talk about on the next slide. So today, only about 4 states, and I believe Washington, D.C., still recognize the contributory negligence rule. So big difference between contributory negligence and comparative negligence. So let's look at comparative negligence, which is much fairer. And as a matter of fact, it's an apportionment of damages. So comparative negligence seeks to assess damages based on the amount of negligence of the respective parties. So some jurisdictions apply the doctrine in its purest form and allow a plaintiff to recover damages against a negligent defendant, irrespective of the amount of the plaintiff's own negligence. Thus, a plaintiff found to be 80% negligent could still recover damages for the 20% of negligence attributed to the defendant. So say a plaintiff was awarded $100,000 as the result of an accident that occurred where the defendant was negligent. But the jury found that the defendant was only negligent 20% and the plaintiff was negligent 80%. In that particular case, the defendant would only have to pay $20,000 of the $100,000 damages. So it's a direct apportionment or division attributable to the amount of negligence by each of the parties. Now, other jurisdictions, again, apply a modified form of comparative negligence. And in these particular cases, a plaintiff cannot recover damages if it's found that they contributed 50% or more by their negligence to their own harm. So again, it's sort of a combination of contributory and comparative. But for your purposes, understand comparative negligence is a direct apportionment, and contributory bars the plaintiff from recovering, from recovering if, in fact, now I forget what I was saying. So comparative is apportionment, contributory bars the plaintiff from recovering if they contributed in any way to their own harm by their own negligence. So the last offense I'm going to talk about tonight is something called assumption of the risk or assumption of risk. Again, it depends upon your particular jurisdiction, what verbiage they use. So this is the act or an instance of a prospective plaintiff's taking on the risk of loss, injury, or damage. Now, the principle that one who takes on the risk of loss, injury, or damage cannot maintain an action against a party that causes the loss, injury, or damage that they knowingly got involved in. Okay, so again, you see this a lot, and it's not used in many jurisdictions. It was, highly popular years ago. One example that you might see lately that's been in the news are some of these amusement parks where people have been harmed on the amusements or rides in these amusement parks. So generally what happens is when you go to an amusement park, you'll buy a ticket. And on the ticket is all this funny little writing that says, we're not responsible if you get harmed by any of the rides here or get, fall or whatever. By partaking of the amusements, you assume the risk of any injury. Well, the courts have found that in most instances, the visitors to amusement parks aren't aware of that language, that tiny little language on their tickets, and also the harm that has occurred from these rides is something that the amusement parks could have prevented by normal maintenance, et cetera, and that the riders should no longer assume the risk despite what is on these particular tickets. And there are a lot of different examples. That's just one example that's been in the news quite often. So basically the underlying premise is one who expressly agrees to assume a known risk, meaning they understand the risk, is generally barred from recovery of damages for the tort of negligence. So originally this particular defense was known as an affirmative defense, but in most jurisdictions it has been replaced either by contributory or comparative. In most jurisdictions it's been replaced by the more apportionment defense of comparative negligence. So if a state does still use it, which very few do, one note is that it requires an appreciation of the danger that is incurred. So again, they must understand that by engaging in this particular activity, this is the type of harm that they could face as a result of such engagement. Misty says, I tell people all the time, take your life in your hands walking in front of my car because I'm a horrible driver. Assumption of risk. Yeah, that would be a good case to try from an evidentiary standpoint. So speaking of cars and assuming the risk, here's an example. Again, it's an older case. It's a 1995 case, but in most instances, it's still good law. So what a lot of people don't understand is getting into a car with an intoxicated driver is assuming the risk. So if you understand that, or you know that the person has been drinking and you get in their car and they're driving, if you're injured as a result of the intoxicated driver, getting into an accident, in some jurisdictions, not all, again, remember, you have to have a state that uses this defense of assumption of the risk, then the defendant can escape liability under the doctrine or defense of assumption of the risk. Now, again, a lot of states don't use assumption of risk, but this is the case, again, from a jurisdiction that did in Alabama. Why does this picture make me think of Super Troopers? I don't know. There you go. Okay. I also just wanted to provide a little bit of a comparison between assumption of risk and contributory negligence, because sometimes these two concepts can get confused. So assumption of risk is knowingly accepting a danger and then voluntarily assenting to exposure to that particular danger that you're aware of. Contributory negligence, on the other hand, involves a departure from the standard of care of an ordinarily reasonable person, meaning that the plaintiff, him or herself, was negligent in making sure that they were not harmed. So assumption of risk example would be deciding to go skydiving. Contributory negligence would be failing to check the parachute and make sure it's properly packed. So again, hopefully that demonstrates the difference between assumption of risk and contributory negligence. Okay, further comparison between intentional torts and negligence. Again, something you're going to want to think about for your discussion board, which I'm going to move to in just a minute. Common element for intentional torts: there must be the intent to do the act that caused the harm. In other words, purposeful conduct that's designed to harm another person or his or her property, versus negligence, which is a failure to exercise reasonable care. There's no intent to harm somebody. There's only a breach of a duty to exercise reasonable care. And again, it may sound like a simple concept, but when you're involved in analyzing a fact pattern, sometimes it gets confusing. Strict liability is the last category. Again, also known as absolute liability. This particular tort was established as a matter of social policy, and all that matters in a strict liability case is whether the defendant engaged in the activity that caused injury to the plaintiff. In other words, the law of strict liability imposes responsibility or liability for damage to an individual or property without any regard to the defendant's intent or negligence. So what this basically means is, even if the defendant did everything correct in utilizing a particular product or engaging in a particular activity, they had no intent to harm anyone, they were not negligent, they will still be found liable for harm if in fact engagement or use of that product caused the harm. This particular body of tort law deals with unsafe products and abnormally dangerous activities. So again, there needs to be involvement of these particular types of things before you can have a strict liability or absolute liability case. And here's just some more on strict liability. Definition of what activity is abnormally dangerous. I'm not going to spend too much time on this. Do look at it. And if you have any questions, do let me know. I also will be sharing more information in the discussion board, but due to time, I want to make sure I show you my other slides and then get to this week's discussion board. So I also went through the different types of damages, again, monetary damages, for the most part associated with tort actions. General damages are more difficult to prove. They're not based on a specific monetary loss. They include the more soft damages or gray area damages, such as pain and suffering. By comparison, special damages are much easier to prove. They're designed to compensate the plaintiff for quantifiable monetary losses. Examples would include medical bills, cost to repair damaged properties, cost for not being able to work, lost wages, things like that. Again, compare this to general damages, for which there's no exact dollar value for the plaintiff's losses. And it's these more general damages where we find really high awards in tort cases, hence, the ask for tort reform by certain members of the bar and others. Punitive damages are very rarely awarded In tort cases, again, it has to be relatively heinous behavior. Sometimes you'll see these in class action lawsuits, tort actions. Those of you that may have, read about or watched the movie Aaron Brockovich, you'll see the damages. These were toxic tort cases, huge settlements. Again, punitive damages are used in some cases like that. Yeah, that was a really good movie, Misty. Really good story, particularly for those of you that want to be paralegals. Anyway, so they're rarely given. They're also known as exemplary damages, and they're considered punishment for outrageous behavior. Okay, now I'm going to move to your only graded activity other than the seminar this week, and that is your discussion board. So the title is Negligence, Torts, and Defenses. Keep in mind what I said before. This discussion actually does not only talk about negligence, it also talks about potential intentional torts. And I'll get to that when I read through it. Okay. While a spectator at a professional hockey game is struck in the face by a puck resulting in injuries. The hockey player shot the puck attempting to score a goal, but shot too high, causing the puck to go into the spectator area. While the plaintiff brings a negligence tort lawsuit against the hockey player, the team and facility defendants. The defendants assert the defenses of assumption of risk and comparative negligence. You're going to, number one, discuss those defenses and the party that you believe will prevail. So what you're going to do for this first part of the discussion board is you're going to break down the defendants. The defendants are the hockey player, the team, and the facility, which would be the administrators or owners of the actual hockey rink. Break them down under the elements or in association with the elements of negligence. Go back to the slide where I broke down those 4 elements. So what is the duty, again, to refresh, what is the duty of care for each of the 3 defendants to the plaintiff, and then walk through the rest of the elements. Now, just to give you a hint, the hockey player had no intent to harm anyone. He was just playing the game. Shot too high. The puck went into the spectator area. So who would have the obligation to make sure that hockey players did not harm, members, paying members of, or any members of the audience? So just think about that when you go through the 3 defendants, because there are 3 separate categories of defenses. Okay, next, suppose the hockey player had been angry at the crowd's loud booing and intentionally shot the puck into the crowd. Would the outcome change? Why or why not? So now you're moving from a negligent tort to an intentional tort. So if the hockey player intentionally shot the puck with the intention of harming someone in the crowd, then that would be using the elements of an intentional tort as compared to a negligence tort, okay? That in you're talking about a civil action. Yeah, there are a lot of good movies dealing with tort law. So again, I want you to be thoughtful in your responses in this discussion board. Be original as much as you can in your posts. And if you still have questions regarding what you're supposed to do or the expectations for this discussion board, absolutely feel free to share your questions in the discussion board itself, or you can always send me an email and I'm more than happy to clarify. So again, it's relatively straightforward. What I'm mainly going to be looking at is your ability to answer each part of the discussion question, as well as incorporate the legal standards for the tort of negligence, the defenses associated with negligence, and the tort of intentional tort, and any defenses associated with an intentional tort. And then finally, do make sure to participate at least 2 additional times in the discussion board. So I know I'm out of time. Thanks for those of you that shared your own stories, your own insight regarding these particular topics. I look forward to seeing you all in the discussion board, and I'll see you next week, same time, same place. Thanks, everybody. Have a fantastic Unit 7. Bye-bye.